This is Bloomberg Law with June Grasso from Bloomberg Radio.
President Donald Trump's plan to send hundreds of troops to Oregon and Illinois to counter protests against his immigration crackdown faced two major tests today in separate courts as state officials continue to raise the alarm about the White House's domestic use of the military. And there appeared to be mixed reactions in the contentious hearings in San Francisco and Chicago. A federal appeals court in San Francisco appeared to back Trump's request to overturn a temporary order barring his deployment of the National Guard to Portland. But a federal judge in Chicago was critical of whether there was legal support for sending troops into that city. My guest is immigration law expert Leon Fresco, a partner at Holland Knight. Leon, tell us about the issue in the appellate court hearing in San Francisco.
This case involved the Portland deployment of National Guard troops into Portland, where the Trump administration was saying that they needed those National Guard troops into Portland to guard the federal ICE facilities and the federal ICE officers who are engaging in their mission. And their argument is that Portland is such a dangerous place that the Guard is needed because their local officials are not sufficient to protect the federal interests that are there in Portland trying to enforce the immigration laws. And so there was a district court opinion that enjoined that use of National Guard for that purpose and said that the Guard couldn't be used for that purpose if it was in contravention to the wishes of the state of Oregon, which is what happened here. The state of Oregon did not want those Guards being sent to Oregon, especially if it was going to be done for the purposes of supplementing or augmenting immigration enforcement. So that's why they had filed the suit originally. This case now went to the Ninth Circuit for a stay of that order so that when it goes on appeal for the merits, that it be stayed so that the National Guard could be deployed into Portland. And although there's not a decision yet, it does look like at the argument, two of the Ninth Circuit judges who were appointed by President Trump were of the belief that, yes, there could be a bright line area where you could be deploying National Guard troops for improper purposes, but we couldn't speculate up front that that was going to happen, and that if the Guard was going to be strictly deployed just to guard the federal interest, that on its face wouldn't be a violation of the rules by which you could deploy the National Guard. And so for that reason, even though a decision is not out, it looks like there will be a decision that will say, hey, look, if this is applied in an unconstitutional manner, come back to us and tell us that. But on its face, we're not going to say that it's unconstitutional to send National Guard to Portland.
So what are the rules for sending in the National Guard? Because the administration has argued in both cases that there's an active threat of rebellion and that the federal government can't carry out the law without the National Guard's assistance.
Well, there's various scenarios in which you can bring the National Guard, and one would be if you thought there was a rebellion going on. And there is certainly that area of debate about whether the circumstances in those locations are tantamount to a rebellion. And that's where, in the Chicago case, there's sort of this argument going on there about whether there's a rebellion or not. But there's also a different part where it's just the Guard can be deployed to guard federal property and to guard federal workers and law enforcement people trying to do their job. So under either of those two scenarios, the National Guard can be deployed. And so the question is just, does the Trump administration have sufficient evidence that that's all they're going to be doing, or will they be crossing the line into enforcement of civil laws, which the National Guard is not permitted to do? And so that's where, when you have this ICE enforcement, it becomes problematic, because if the courts start to think that the National Guard is basically part and parcel of ICE enforcement, then that's unconstitutional and that's not permitted. Whereas if the Trump administration can sort of make this periphery type argument that no, they're not enforcing immigration law, but they're protecting the ICE agents, because what happens is whenever ICE tries to work in these towns, they're getting harassed, they're getting things thrown at them, they're getting cars being driven into their cars. and all kinds of other violent acts that they need protection, then that argument starts to have more salience than if they think that what the National Guard is doing is not protecting these ICE agents, but actually force multiplying immigration enforcement in those areas.
The two Trump appointees really grilled the lawyer for Oregon. Judge Ryan Nelson asked why Oregon and the city of Portland should be able to second-guess the president's determination about the level of disruption the protests were causing. So the president who's sitting in Washington is going to determine the level of protests? When a judge in Portland, a Trump appointee, found that Trump's conclusions were not tethered to the facts?
I do think if there is the debate on what the level of violence is in Portland, as opposed to cabining it to protection of federal facilities and federal officers, and that we're instead talking about, is there too much of an insurrection going on, supposedly, in Portland or in Oregon, that would then justify the National Guard being brought on that basis to be able to just generally protect law and order, then I do think that argument, if it goes en banc to the Ninth Circuit, because that argument may prevail 2-1 in this panel, but if it were to go en banc to the Ninth Circuit, it would probably be overturned. And then the Supreme Court's going to have to decide what level of deference goes to the president for this kind of larger law enforcement, sort of keeping the peace type of National Guard. And that's going to be brand new law that we're going to have to see what the Supreme Court does with regard to these arguments that, wow, things have gotten so bad that we need the National Guard to actually calm things down. So they're not just going to be protecting federal facilities, and they're not just going to be protecting the ICE officers, but they're actually going to be protecting everybody because things have gotten so bad. And so to the extent that the Trump administration doesn't want to cabin what the Guard is doing to just the federal protection, then they're going to need to rely on this larger argument that the president gets deference for what the president deems is the threat level in that area. And then now it's going to be for the courts to decide, is the president entitled to that deference, and for how long of a period of time, or does the state get that deference since it's their National Guard that's being put into service?
Because appellate courts are supposed to defer to the district court judges as fact finders, but these two appellate judges didn't seem to be doing that, didn't seem to be crediting the district court judge at all.
Well, they may think that the district judge is right on the facts, but that at the end of the day, the district judge doesn't have any authority to make any factual findings if the decision they're going to issue is that basically it's not cognizable that a state can come in and sue and say, we disagree with the president's assessment of the threat level in the state. So if that's really where they're going, then they're going to have to figure out some lines that they're drawing in order to not make that where the president can deploy the National Guard for any purpose that the president wants. But it's possible that this 2-1 panel may issue a decision that says that the president gets either complete deference or almost complete deference to decide when to deploy the Guard, and then we'll have to see when the en banc panel of the Ninth Circuit were to intervene, or perhaps the Supreme Court, what they would say about such a conclusion.
Oregon would probably be luckier if it's just the en banc panel. And I just want to explain that on this panel you had a 2-1 situation, 2 Trump appointees and 1 Clinton appointee. Looking at all the judges on the Ninth Circuit, there are 13 Republican appointees and 16 Democratic appointees. So if there's an en banc hearing, the odds are better for Oregon.
In certain courts, the entire court, meaning all of the active judges, actually sit there and would look at the case. In the Ninth Circuit, there's too many active judges. And so they actually also have a panel. It just happens to have more judges in it. If they have a panel of 12, which is what their en banc panels are, in that 12-judge panel, we still don't know what the takeaway is. But yes, it is more likely that there will be a panel that contains fewer Trump-appointed judges. And even there, even if a judge was actually not appointed by Trump, but was appointed by a other Republican president, sometimes even those judges have shown less deference to the Trump administration than the judges that have been specifically appointed by President Trump.
There was a hearing in Chicago today before a federal judge about Trump's deployment of troops to Chicago. So it seems like the lower court judges who are looking at the facts on the ground have different opinions than the appellate court judges in these situations. Tell us about what the issue is there.
Correct. It's the same argument again, that the president's determination about the cities, whether they meet the legal standard for bringing National Guard troops under federal control. And again, here there's two issues, which is, are the guardsmen going to only be protecting federal property and federal agents, or are they going to be stopping a violent insurrection? And what the judge is saying in the Chicago case is, well, what are you doing? And so the judge started asking a bunch of questions to the DOJ, which I think was the correct way to do this, to try to say, which argument are you resting on? Are you resting on this is only federal property, or are you saying that the situation is so bad that you're going to be doing other kinds of enforcement? And because the DOJ attorney really, I think, probably didn't have a answer on what the full mission was going to be for these National Guard coming into Chicago, rightfully couldn't sort of give the most precise answers to all of these hypothetical questions. And so looks like the judge is going to enjoin the National Guard, just like the Portland district judge did, saying it looks like you're going to be going beyond the federal protection situation. And because of that, you haven't shown the facts that you need to on the ground to be able to show that you can deploy the federal National Guard for any other purpose here.
Yeah, the judge, and this has happened in other hearings, said she was troubled by what she described as a disconnect between the official orders from the federal government directing the activities of military troops in Chicago and the public statements, the rhetoric made by Trump about what their duties in the city are. Trump keeps talking about crime, and when the prosecutors get into court, they talk about how this is, limited. So the judge said, what I am troubled by at the moment is when I try to nail down what of those things that they will do, you don't really offer a clear answer. Probably because they don't have a clear answer.
Right. I don't think the attorney probably has a clear answer, because I do think the mission hasn't been defined with the level of specificity that would give the attorney a clear answer. And so for that reason, I think that that's just a unfortunate situation for that specific attorney to be in, but that's the reason why this judge is then going to say, fine, then what you're trying to do is you're trying to deploy the National Guard for a broad purpose, not just for the federal purpose, and since you're not willing to foreclose this, and so because of that, you haven't submitted enough factual basis that there's enough chaos and insurrection going on that you need the National Guard to come in to stop such conduct from occurring.
And then we'll see what the Seventh Circuit says. Coming up next, we're going to talk about some other immigration issues, including lawsuits over the high price tag Trump has put on H-1B visas. I'm June Grasso, and you're listening to Bloomberg. Now to the continuing legal saga of Kilmar Abrego Garcia. The Salvadoran man deported in error to El Salvador last March and then returned to the United States to face criminal charges in Tennessee. Could he be released on Friday? I've been talking to immigration attorney Leon Fresco of Holland Knight. Leon, it's been about 7 months since the case of Kilmar Abrego Garcia was in the headlines. Tell us where his case stands right now.
So in the Kilmar Abrego Garcia case, this was the individual who got sent to El Salvador, who had a protection order that said that they couldn't be deported to El Salvador specifically on the basis of gang violence, not on the basis of detention in that CCOT facility, which is the facility for terrorists that the President Bukele made in El Salvador. But nevertheless, there was an order specifically saying that Abrego Garcia couldn't be deported to El Salvador, and nevertheless he was. And then the question was he ever going to be brought back? He ended up finally being brought back because there was an extradition on human trafficking charges. The human trafficking charges judge let him out on bond and basically said it doesn't look like there's really a much of a case here for human trafficking. So he was placed back into immigration detention to try to undo the order that executed the removal to El Salvador that said there's no more gang violence in El Salvador because President Bukele has stopped it and has actually put in this prison, etc. And they did get an order that basically said they could do this deportation, but it has to be to a different country. And so Abrego Garcia has actually stipulated, fine, I'll go to Costa Rica. And the United States government's current position is, no, we don't want to send you to Costa Rica. We want to send you to what was formerly known as Swaziland, which is a little landmass inside of South Africa, which is now called Eswatini. And that's where we want to send you, to which there is case law called Zavidas versus United States, which says once you're in that situation where the government has said they want to deport you to a certain location, if they can't show that it's significantly likely to happen in the foreseeable future, they have to let you out of detention. And so that's the current fight is, fine, you're not going to send me to Costa Rica. You want to send me to Swaziland / Eswatini. How quickly do you plan on doing this? Or are you just going to keep me in detention for the foreseeable future? And there's a hearing on Friday. If the court doesn't get a date certain for this removal, the court is probably going to let Mr. Abrego Garcia out of detention again, which I think will very much upset the Trump administration, and then they'll have to make some decisions. Do they just send him to Costa Rica then, or unclear what they'll be willing to do in that situation?
Why would there be a problem or a delay in sending him to Eswatini?
It's possible that the Eswatini government does want to accept, they have already accepted some people, but they may not want to accept Mr. Abrego Garcia specifically, or they may be trying to figure out some plan for what they're going to do with him when he arrives. And so these reasons for delays are very unclear, but they're going to have to come up with a date certain. That is for a fact. So that if they don't have a date certain, then the judge is probably going to let out Abrego Garcia on Friday.
He would be let out temporarily or permanently?
Temporarily until there's a date certain. They can place him immediately back in detention if they can come up with a date certain for deportation. That they can say, okay, we have the travel documents. We're now going to deport him on October 21st or something.
Leon, how often does the government deport people to countries where they have no connections at all?
So it's not unprecedented prior to the Trump administration. I was involved in a very famous case when I was in the Department of Justice where there was a Palestinian terrorist who blew up a plane in Hawaii, and he actually got a plea deal. And in this plea deal, he was only given 25 years in prison because he was supposed to turn in other terrorists, and he actually didn't end up doing it. And so the 25 years ran out, and there was no place to deport him because Israel didn't want to take him. And so the question is, what were we going to do with this person? Were we just going to let them out and start walking around the United States when this person had blown up an airplane? And so the U.S. government made negotiations and actually got Mauritania to take this individual. So this does happen in cases like this, but the Trump administration is trying to deploy this in a much broader fashion. They're sending people to Ghana, to Eswatini, to Libya, to El Salvador, to many other countries, and they're actually having visa negotiations with countries that are very interested in having foreign students and other foreign nationals get visas to come to America, and they're saying, fine, if you want better treatment on that, you will have to agree to accept people we're trying to deport from other countries. And so some countries like Ghana have said yes, and other countries have said no, but it's going to be very interesting moving forward. And by the way, the idea for this is twofold. One is to be able to execute deportations in cases where you can't currently do it. So there's just the nuts and bolts of it. But secondly, it's also a massive deterrent where, let's say you're from a country like Cuba or China, and you say, oh, well, there's no downside to coming to the U.S. illegally because China won't accept me or Cuba won't accept me. Well, now the government can say, yeah, but how about if we send you to Libya or South Sudan? You're not going to like that too much, so don't try to come here. So it's to give also that extra layer of deterrence so that people won't come here thinking that their country won't accept them back.
You know, we talked before about President Trump putting a $100,000 fee on new H-1B workers' visas. And so a coalition of employers is suing. Isn't it up to the federal government to set the fee?
So this is going to be a very interesting case. It's a coalition of unions, universities, nursing companies, and professional organizations. And what they're saying is that the way this fee works is if you want to put in the fee, you have to actually go through the regulatory process of the Administrative Procedure Act and actually do the whole notice and comment and do the year-long regulatory process with all the analysis on the economy and everything else. You can't use the travel ban authority. And so this is going to be an argument because the travel ban authority says very specifically the president can put any terms and conditions the president wants on the entry of people into the United States. But the H-1B statute says that any changes to the H-1B program has to be done vis-a-vis regulation. And so there's two statutes that literally conflict with one another, and the court's going to have to decide which one governs here.
And finally, we've also discussed before Venezuelans' temporary protected status. And this seems to be in the category of the lower courts rule one way, and then the case gets to the Supreme Court, and the Supreme Court reverses. So the Supreme Court is allowing Trump to lift the temporary protected status of Venezuelans?
Correct. This has happened twice now, where what happened was first there was a preliminary injunction, and in the preliminary injunction, the court ruled, the lower court, the district court ruled that the president could not get rid of temporary protected status from Venezuelans because the idea was that the administration didn't do the analysis of what was actually happening in Venezuela and predetermined the outcome, and so it was not a proper revocation of temporary protected status. The Supreme Court put a stay on that temporary injunction, and so everyone thought, well, that's over. The Venezuelans have lost their temporary protected status. End of story. Then the district court said, well, that stay was only of the temporary injunction, but now I'm issuing a final injunction, and so I'm not bound by that court stay, especially because the court didn't actually explain. They issued one of these one-line opinions lifting the injunction, saying, hey, we're staying the injunction. So I don't know what the basis was, but maybe they didn't like something in the temporary injunction, but now I'm issuing a final injunction that is really looking at the evidence of what was considered, so I have the ability to do this again. So the court again said the Venezuelans keep their temporary protected status. Everyone was happy again in the Venezuelan community, but now the government appeals it, and then the Supreme Court issues the exact same order again, staying this protection. So now, as of November, the temporary protected status will be gone, and all of these Venezuelans, hundreds of thousands of them, will be in illegal status, subject to deportation, and it's going to be very complicated what's going to happen with all of these individuals.
Leon, are there any other groups of foreign nationals who still have temporary protected status?
The only country that has temporary protected status that has not been disturbed, interestingly enough, because it's actually what I would argue the most stable because of who the president is El Salvador. But El Salvador obviously has the president that's most friendly to President Trump, and it appears that obviously some arrangement was made to keep the El Salvadorian TPS available. So that's the one country that has kept its temporary protected status.
That certainly seems odd. Thanks so much, Leon, as always. That's Leon Fresco, a partner at Holland Knight.
What you're sketching out for us is a potential disaster. In other words, you're saying if the candidate's going to win by 65%, no standing. But if the candidate, hopes to win by a dozen votes, and there are places in the country where that happens over and over again, then he has standing. But we're not going to know that until we get very close to the election, right? And so it's going to be in the middle, the most fraught time for the court to get involved in electoral politics. That's when you say we should jump in.
Chief Justice John Roberts painted a bleak picture of judges having to make decisions close to an election about whether a political candidate has the legal right to sue over their state's election laws based on the candidate's chances of success at the ballot box. The chief wasn't alone in that assessment. A majority of conservative justices seem to feel the same. Illinois Republican Congressman Mike Bost is challenging the state law that allows mail-in ballots to be counted if they're received up to 2 weeks later. The Seventh Circuit threw out Bost's case, finding that the veteran congressman didn't have standing to sue because his claims of the law hurting his chances were speculative at best. But the conservative justices appeared open to allowing Bost's lawsuit to proceed. They seemed skeptical about the idea that a candidate's vote totals should affect their ability to sue, and a court making that decision. Here's Justice Neil Gorsuch.
And then along the way, is there something unseemly about federal courts making prognostications about a candidate's chance of success immediately before an election that itself might influence the election?
But the liberal justices questioned whether Bost had shown evidence that he was harmed by the law. Justice Elena Kagan told the Assistant Solicitor General Michael Talent that it seemed like the suit was one in search of a problem.
I mean, I guess I just sort of think, what's the problem here?
The problem here, and what our rule gets to, is the fact that candidates are forced to gamble that these ballots are going to affect the outcome of their election.
I don't think we've ever actually asked the RNC or the DNC to do anything like that. What we've asked the parties to do is and this is why you don't get these cases thrown out on standing grounds, because there are perfectly easy ways for a party to say why a new rule is going to harm them in the electoral game.
Illinois is among 18 states and the District of Columbia that accept mail ballots received after Election Day as long as they're postmarked on or before that date. Joining me is elections law expert Richard Briffault, a professor at Columbia Law School. Rich, tell us about Bost's lawsuit.
So in this case, Congressman Bost is challenging Illinois' law that permits mail-in ballots to be counted up to 2 weeks after Election Day, provided that they are postmarked as of Election Day. Basically, it allows local boards of elections to count late received ballots, provided they were actually mailed as of Election Day. His claim is that with respect to a congressional election, this violates the federal law that says that we have a single election day, and that's the second Tuesday in November.
A lower court found he didn't have standing to sue. Tell us about the lower court's decision.
Right. This was the lower court in Illinois, where he's from. Basically, he did not claim that this was going to cost him the election. He basically claimed that this could affect his share of the vote, and that it also costs his campaign some money to keep staff going to monitor the late counting of the ballots. But he didn't make the argument that he was likely to lose, that he had a substantial risk of losing his election because of this. So the lower court, and actually the Court of Appeals in the Seventh Circuit, found that meant he didn't have standing. That standing generally requires that you make an allegation of harm, and they felt he had not alleged any harm, which is to say losing an election.
He won by 75% of the vote.
Right, and he's an 8 or 10 term member of Congress, and this law in Illinois has been on the books now for quite some time. So he's run and won at least a half dozen, possibly 10 elections under this rule.
What's the threshold legal question here?
Well, the question is whether he has standing. I mean, this case is being read against the backdrop of the challenge to absentee ballots, the ultimate merits question of whether or not it violates federal law for states to continue to count mail-in ballots after Election Day, provided they're postmarked before. Indeed, there's a decision out of the Fifth Circuit that involving Mississippi that says it does violate the law. This is ultimately going to be about that, but the question before the court at this time is standing. What are the conditions wherein a candidate standing to challenge an election law before the election? And Congressman Bost and his lawyer are basically arguing that the fact that he is a candidate inherently gives him standing, that candidates by definition have standing to challenge the laws that govern the running of elections. He also has some backup arguments, but that's in some sense his argument number one is he is a candidate, therefore he has standing.
And what is Illinois arguing?
Illinois is arguing that under basic standing doctrine, general Supreme Court standing doctrine, you have to make an allegation that there's a substantial risk of harm, and that he hasn't argued that. He hasn't shown that this is likely to cost him his election, and therefore that he doesn't have standing, that he hasn't alleged that this is actually hurting him.
Many of the majority of the conservative justices seem to be signaling support for Bost. Why?
That was my reading of the argument. And there is one pretty good argument on his side, which is, although it's not clear how it fits with traditional standing doctrine, which is it's good to get these challenges out of the way before the election. It's better to have this issue of whether or not late received absentee ballots can be counted resolved a year before the election than after the election, when everyone might know that it could actually affect the outcome. So I think as a general rule, there's broad agreement that challenges to election laws ought to be resolved outside the context of a current election. And I think that's what they were largely reacting to.
Several of the justices, I think the Chief Justice and Justice Kavanaugh, were talking about how requiring candidates to show that a new voting rule created risks would put judges in the prediction business.
Yeah, I mean, again, the state's argument is he hasn't shown that he's fearing a risk of harm. He's been elected and reelected overwhelmingly in his district many times. And the state was arguing he's got to make some claim consistent with general principles of standing law that this law creates a risk of loss for him, risk of harm. But as you say, the Chief Justice, Justice Kavanaugh, was saying, well, that means that you're going to require judges to make a guess as to whether he's a shoo-in, in which case he doesn't have standing, or he's a likely winner, but there's a chance he might lose, and therefore he has a standing. And then even the question of, well, what about if you're bound to lose, if you're from a minor party, or you're a party that always loses this district? Does that mean you can't sue either because you can't show you're any worse off because you're going to go from 5% to 4%, or conversely, you're going to go from 90% to 85%? They were saying that the state standard, it basically invites judges to get into this kind of political predictions, which they shouldn't be doing.
So the liberal justices seemed skeptical of Bost's claims, and Justice Kagan said, I have a sense this whole suit is a little bit in search of a problem. There are perfectly easy ways for a party to say why a new rule is going to harm them in the electoral game. So let the party do it?
That was her view. Her view was that, in fact, parties have been bringing these cases, and it's unclear why the Republican National Committee itself didn't bring the case, or the Illinois Republican Committee. In some ways, the best argument for Bost's position is that it's a good idea to get these cases resolved early. Her response is, that's fine, but you didn't need him to bring the suit. The Republican Party could have brought the suit. And the liberals, I think, had some concern about how does this fit in with traditional standing doctrine. So Kagan is maybe the least hostile. It seemed to me she was looking for a way to allow the case to find standing, although maybe not on the same terms as Bost's argument. It seemed to me she recognized the power of the argument that there should be pre-election litigation of this. But she, like the other liberals, was skeptical, didn't quite see how this fit into traditional standing rules. Is
there a fear that ruling for Bost would open the floodgates to challenges of all sorts of state election rules?
That was the argument that the state raised, that you're right, that this means unless there's a real standing, unless there's a real serious risk of injury, anybody could bring any lawsuit, and that this basically opens itself up to, in effect, open-ended litigation. There's something to that. On the other hand, as I think either Roberts or Kagan said, these suits are being brought anyway, and there's a lot to be said for the argument of let's have the suit decided before the election rather than in the heat of the election or after the election.
So there were some unusual alliances here. The League of Women Voters and the ACLU, among others, filed a brief in support of Bost's right to bring this legal challenge.
That's right, and it's on that theory. I suspect that they would be against his position on the merits, about whether or not federal law prohibits counting of late received mail-in ballots. But I think they agree with the idea that it's good to get these questions resolved early. It's good to get these questions resolved before the votes have actually been cast.
Trump has been vociferous about mail-in balloting leading to fraud, etc. And there are several lawsuits brought by allies of Trump questioning the guidelines in different states around mail-in ballots. Will this decision impact those efforts to stop the practice of states counting mail-in ballots after Election Day?
Assuming that Bust wins, it will, move that issue one step forward to judicial resolution. Although I believe there's already a case in which a lower court found that late counting, again, it's post-Election Day counting of ballots mailed in by Election Day. At least one lower court has said that does violate the federal law setting a single national election day. Again, that's only relevant as to federal elections. So my guess is one way or the other we're going to have this issue before the Supreme Court very soon. My guess is that issue is going to be resolved whether or not he wins this case.
Thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.